Now we're resuming after the break. In recap, in the first half, we looked at the background of Nissan and Ghosn. We looked at Ghosn's criminal case in Japan, the substance, and some procedural issues briefly. The substance was 4 counts, 2 counts of false disclosure reporting of compensation and 2 counts of misuse of corporate funds. And the procedure controversy focused on Ghosn's treatment, arrest and detention, and also interrogation. In the second half, we'll look more broadly at Japan's criminal justice system from a comparative perspective. One major focus will be the work I tried to make an apples-to-apples comparison on conviction rates in the US and Japan as one of the most controversial supposed facts that was cited often. We'll have some additional background on Japan's criminal justice system, and then a brief return to how the system handled the Ghosn case. Finally, a few words on possible reform of the criminal justice system in Japan. So here are the data I came up with after close consultation with my colleagues. So how do you compare conviction rates? What's a conviction? In both countries, the bulk of cases are processed through guilty pleas, and there's no real contentious case. So I thought, well, let's look at the respective conviction rates of cases that are actually contested where there are no guilty pleas. Maybe that's at least much closer to an apples-to-apples comparison. This is not typically done because the US and Japan use the data in categories in different ways. The question basically is, we know how many people are acquitted. It's a small number. So when we talk about convictions, the real question is, what is the denominator? Convictions among what group of indictments or cases? So the first line we see under indictments, we see the first big difference. In the US, the indictment phase is not a major way of dealing with the bulk of the cases. Most of the cases that are referred to prosecutors are indicted. In Japan, under a third of cases referred to prosecutors are indicted. So the main mechanism for dealing or processing cases within Japan is simply not to indict, which is quite different from the US. For people who are indicted, most people plead guilty. The percentage of contested cases in the US is under 3%. Everybody else plea bargains and pleads guilty. In Japan, it's 10%, a little bit higher, but in Japan, they've already weeded out many cases at the stage of indictment. So the real question is, what's the conviction rate for these contested cases that go to trial and defendants do not plead guilty? Roughly speaking, in the US, it's about 83% conviction rate, and in Japan, it's 96% plus. So that's using the same denominator of contested cases where no one pleads guilty. Then what's the conviction rate? If we go to the bottom row there, conviction rate of all indicted cases, in both countries, it's over 99%. So here's a difference in treatment. In Japan, there's no US-style arraignment. If you are indicted, you go to trial, whether you plead guilty or not. So even if you plead guilty and confess, the trial may be short, but you cannot be convicted solely on the basis of your confession. There must be some other evidence. The prosecution still carries a burden of proof, so you go to trial. So in Japan, when they talk about conviction rates, it's the bottom one, conviction rate of all indicted cases. In the US, when we think of the term conviction rate, it's really conviction rate of contested cases. And these are two very different denominators and different rates. So the bottom row indicates, if we look at the US statistics and use the Japanese approach of guilty pleas are still convictions, if you're indicted, then both countries end up with over 99% conviction rates. So the conclusion is, despite what we've been reading in the Ghosn commentary, the similarities are probably greater than the differences between the US and Japan. In both countries, there are many guilty pleas and very few contested cases. And among the contested cases, there's a strikingly high conviction rate. This might be because in the US, there's a higher conviction rate than people realize because of our relative emphasis on the rights of defendants. There's also some data issues, which I'll get into in a minute. So in conclusion, the strong criticism of Japan's system as hostage justice compared with some somewhat idealized version, perhaps, of the US system is not valid. So this is sort of the conclusion. I'll spend just a few minutes going over some of the data. So first, the US data. In the US, the federal data is only the tip of the iceberg. Most cases are at the state level, but the states have poor data and it's not centralized. So I use the federal data. This first slide is just to show the indictment rate. So in 16.4% of the cases, there was no indictment. So that means in 83.6% of referred cases to prosecutors, there was indictment. And the main slide is this one. These are the conviction rates. And we always have some issues about what categories to include. There are some misdemeanor cases, not a lot, but some, 8,000 out of 76,000. I excluded them. There are some dismissal cases after indictment. And this could be for a large number of reasons. IR tells me this isn't really a practice in New York at all. Probably in Japan, this would happen before indictment. So I also decided to ignore or exclude these dismissal cases. So all the percentages change a little bit. So here, guilty pleas, 91%. Trials are these two, 2.2 and 0.4 would be 0.6. And so the conviction rate for contested cases is this 0.4% of, I'm sorry, 2.2% were convicted out of the 2.6% of all contested cases, adjusted slightly for ignoring the dismissals. So it's relatively straightforward once you decide to compare contested cases. On the Japan side, Japan is a unitary system and they have excellent data, very consistent from year to year. Here's sort of the outline of their process from their white paper on crime. And you can see prosecuted versus not prosecuted. Many cases are not prosecuted, as I already mentioned. Interestingly enough, though, this very complicated diagram does not show contested cases. And you have to look for other data sources to find them. And so they exist in English, which I wasn't aware. Got some help from Joe Giacchi if you found them. So here is the indictment rate. It says 31%, but again, I threw out the juvenile referral cases. Prosecutors cannot prosecute juveniles. We don't know what happens once the cases are referred to family court. If you exclude this section, then the percentages change a little bit. So I think I came up with a 32% prosecution rate. And here's the conviction rate. I ignored summary courts as I ignored judge magistrate courts in the US as being relatively minor cases and a small percentage of what we're talking about. There aren't too many of those cases, maybe 10%, comparing summary court cases and district court cases. If we stick to district court cases, the acquittal rate recently is 3.44%. So the conviction rate is over 96%. We can't get too precise with the various categories we're juggling. So I tried to not give an illusion of close precision, but it's, I said in the table at the beginning of the section that the US rate was something like 83%, and the Japanese rate was over 96%. Conviction rate for contested cases. Which I think is relatively high on both sides. So how have people looked, as sort of background, how have people looked at the Japanese criminal justice system, particularly with respect to conviction rates or actions of prosecutors? Probably the best known source is David Johnson's book. I thought I was doing brilliant work with my colleagues at Exali when I decided we should compare conviction rates in contested cases. I thought that was great. And then David Johnson was kind enough to give me a comment about when was the last time you took a look at my book, Bruce? And sure enough, in 2002, he had already done that. And he concluded that Japan's conviction rate was not as high as advertised or as discussed, but it was still very different, still significantly different from the US rate. For the US rate, he used state data, which has a lower conviction rate than the federal data. And when I showed him my data of 83% conviction in the US on contested cases and 96% in Japan, he still felt that was quite different. If you take the acquittal rate, it's maybe 4% in Japan and 17% in the US. And he said the acquittal rate in the US is still 4 times higher. I'm not sure that I agree with that characterization. I think my takeaway is that the conviction rates are high in both countries. But so there is still that area of disagreement, I suppose. Mark Ramsauer started out by hypothesizing that judges were pro-prosecutor, but after he did all his statistical analysis and concluded that rather than that, the real issue was probably that prosecutors were being careful. That was his main factor in explaining the high conviction rate in Japan. More broadly, how have people looked at Japan's criminal justice system? David Johnson again, probably more similarities than differences between Japan and the US. He did surveys of prosecutors in Japan and surveys of prosecutors in Seattle, thought that they had the same top priorities. But after that, the Japanese have a strong emphasis on rehabilitation, reintegration into society, and concern with the rights and position of victims, which the US does not have. So there are many basic similarities, but also, I guess, some significant differences. Dan Foote kind of looked at the rehabilitation benevolent side or bright side and compared and contrasted that with the reliance on confessions and limitations on individual rights practice that resulted. And then we have 2 other views on how Japan fits in comparatively, which I think are both interesting, and maybe we'll get a chance to mention this again in Q&A. So the most fundamental common problem is the potential for coercion. It manifests itself in different ways in the US and Japan. In the US, it's through plea bargains. I don't know the exact data, but even years ago, there was a significant trial penalty if a defendant in the US does not accept prosecutor's offer of a plea bargain and goes to trial and is found guilty, the sentence is usually more than twice whatever the prosecutor was offered. So that is a major point of potential coercion. And in Japan, it's confessions under lengthy detention. Just one brief word. In response to all this recent criticism from Ghosn and the Western media, Japanese Ministry of Justice on their website often defends themselves by citing constitutional provisions. And if you look at the Japanese Constitution, they seem to have all the defendants' rights covered relatively thoroughly. I think it's worth mentioning, though, that there is some difference between the constitutional provisions in actual practice, or interpretation of them in actual practice. To give just a few examples, right to silence, Constitution says no person shall be compelled to testify against himself. A Supreme Court decision in 1999 says that the defendant can remain silent, but has a duty to submit to questioning. And requiring your presence at questioning does not deprive you of your right against self-incrimination. The Constitution says that you cannot admit a confession and evidence inter alia if it occurs after a prolonged arrest or detention. That's like, I guess, like a speedy trial in the US. What is prolonged detention? There are cases where 6 months detention is okay, and it's not prolonged. In the Code of Criminal Procedure, there is no mention of interrogation as a ground for detention, but it frequently in reality is. So people are always trying to deal with the provisions of the Constitution and how they are interpreted and what are the actual standards in practice. So that's at least some sense of maybe what the system is in practice, just a very brief picture of it. So going back, taking another look at the Ghosn case, how did the Japanese criminal justice system do in the Ghosn case? The Ghosn case is atypical, as I mentioned. Usually defendants will say things may have happened, but I had no intent or knowledge of what was going on. Ghosn only says, well, nothing happened, and it's all a plot against. So for all these reasons listed here, lengthy pretrial detention, a real flight risk, as we certainly found out after the fact, Ghosn would not even give his side of the story or what he thought the facts were. And also because of the amounts of money involved, $140 million in compensation and retirement benefits, and 2 more serious counts. Who knows if he would have got jail time, which would have been very rare in white-collar cases in Japan. And we also don't know because Ghosn, other than denying everything, didn't really defend himself, and instead, I guess was successful, at least to some extent, in shifting the focus on the Japanese criminal justice system itself. Was he successful in that effort? I guess to some extent he was, although I think he lost some goodwill in the Western media when he fled to Lebanon. He also lost his $140 million in compensation and forfeited $13 million in bail when he fled, so I guess it's something of a high price for freedom. There was an ongoing investigation in France, and I expect that he may be indicted there as well. I don't know for sure, but they have most of the same information that the Japanese prosecutors had. So we may get a chance to see if Mr. Ghosn thinks that the French criminal justice system is a real justice system that should be respected, unlike the one in Japan. Again, how did the Japanese system do? Much of the focus was on the lengthy and repeated pretrial detention and interrogation without an attorney. And that's a weakness of the system that, again, received lots of attention. At the same time, there was unusual give and take between the prosecutors and the judges. Judges did not grant the full periods of detention. They released Ghosn on bail. And so it's hard to say for sure. Shortcomings were highlighted. At the same time, given that the practice in Japan is that people are detained for interrogation, there was more back and forth than usual, and I think the Ghosn case both highlights areas for potential reform and also shows that the Japanese system is not as uniform or biased as some people have claimed. Here's a question that I'm asked regularly. So how would this have been handled in the US? Well, there was an actual case. the SEC, but it was only for the disclosure counts and not for the more serious misappropriation of company funds counts. So for the disclosure counts, all parties settled without admitting or denying anything. The SEC had an administrative proceeding against Nissan, which settled for $15 million, plus a cease and desist order. A civil case against Ghosn and the other director, Kelly, in New York Southern District. Ghosn settled for $1 million, cease and desist order, and a 10-year bar on being an officer or director of a listed US company. Kelly paid $100,000 for aiding and abetting. The SEC, I put the URL up here because the SEC documentation has the best recitation of the facts of the case that I have seen. They did get some cooperation from prosecutors in Japan. So Ghosn was not arrested, but again, it was only the disclosure counts that were at issue in the US. The bottom half of the slide is pure speculation, but I thought it was a useful exercise to highlight sort of similarities and differences between the US and Japan. And this came from a person on a panel that was held at Columbia Law School, former prosecutor, who gave his view of what Ghosn's treatment might have been in the US if there were sufficient evidence to prove all 4 counts against him. Basically, it would have been the US version. The prosecutors would have been interested. Normally, you would not be detained in a white-collar case in the US, but Ghosn was a good candidate for being detained because of the flight risk. He wouldn't have been interrogated. I wouldn't have had to be present for questioning. However, potential jail sentences are much longer than Japan, so there would have been pressure to come to a plea bargain and plead guilty. Although Ghosn, being a large personality, might have managed to resist that pressure. One takeaway I've come from talking to a number of current and former US prosecutors is that people involved in the actual criminal justice system in the US do not have an idealized view of defendants' rights. You might not be surprised to hear that. So they tend to have a different view from the commentary I was exposed to for the Ghosn case. It is somewhat hard to compare the two systems, but people who are actively involved in the US do not seem to have the impression that Japan is a lesser or worse criminal justice system. So a few quick words on criminal justice reform in Japan, getting a little bit further away from my area of expertise, but Mark Levin at the University of Hawaii pleaded with me to put this up. Ghosn's attacks on Japan's criminal justice system were certainly not the first ones. The questions of detention and interrogation, I'm not talking about the death penalty today, which is shared by the US and Japan, only the US and Japan among advanced democracies. But detention and interrogation has been an issue for some time, strongly criticized by legal professionals within Japan and by international organizations like Human Rights Committee of the United Nations. I think the biggest problem for reform or issue for reform, everywhere we're trying to balance the concerns of public safety and individual rights. And in Japan, they had a balance. Compared to the US, prosecutors in Japan traditionally lacked certain tools of investigation that are noted here. There was no plea bargaining system, no immunity, no wiretaps, no undercover operations. But then defendants also in practice found it difficult to avoid detention and interrogation and pressure for confessions. And there's been kind of gradual evolutionary reform on both sides. And my non-expert sense is that they're trying to reform while keeping this balance and not disrupting things too radically. And so what was done, 20 years ago, you could have said prosecutors in Japan didn't have these tools, and now you can no longer say that. because in recent years there has been at least some introduction of wiretapping, conspiracy charges, immunity, plea bargains. And there have been some evolving practices that are more favorable to defendants to some degree in terms of detention and interrogation. My personal sense is that these reforms have not yet had a huge impact on the day-to-day practice, but there are people who are participating today who know more about this than I do. So I look forward to hearing their comments. Probably the biggest, in my informal survey of Japanese legal professionals, the one feature of the Japanese system they most object to is the fact that lawyers are not present during interrogations. So I've highlighted this as maybe one area that is ripe for reform, although there may also be questions about maintaining the balance and what would, if you can't get confessions, what do you do instead? So here are my very tentative conclusions. I think the bright side of the Japanese system, the rehabilitation, reintegration, is real. The results are good. Hard to know what the exact relationship or causal relationship is, but Japan has among the world's lowest rates of crime, incarceration, recidivism, gun ownership across the board. In contrast to the US, I don't see how you could call a Japanese system a failure in that sense. One of the problems at the moment is that jails are emptying out as the crime rate continues to decline. So there's some question whether they can get enough budget at the Ministry of Justice to maintain the jails adequately. As for the Ghosn case, being an optimist, I try to look at the positive, and I wonder if the highlight or attention that the Ghosn case caused on some of the shortcomings of the Japanese criminal justice system may help spur reform, and only time will tell on that. Unsurprisingly, as in any comparison, there are similarities and differences. I still think that the fundamental issues tend to be similar in democratic societies. And when you have to process a large number of cases with limited resources. And the methods are different, but they both share the common potential problem of coercion. And of course, apples to apples, good comparisons are wonderful, sometimes challenging to achieve, but I'm still trying to follow Jerry's advice from 45 years ago about don't compare my theory to your practice.